so sorry.
You're nervous, right? Have you ever testified before? Okay, can you please answer audibly for the record?
Michelle McCaleb.
Okay, thank you. And
Pull
you've
that
never
microphone.
testified, correct?
Scoot that microphone up.
You know the defendant, Mr. Landon Gray.
Yes, he's the father of 2 of my grandchildren.
No one here's mean. Everyone's nice,
No.
folks, okay? So nobody's gonna get you. So
I'm sorry, just seeing him in those shackles just hurt me.
Okay, it's okay. Now, you said Mr. Gray is the father of 2 of your grandchildren.
Yes, sir.
Where does Mr. Gray reside?
Before he came to jail, he was residing in Waverly, Tennessee.
And based on your understanding, how long has he lived in Waverly, Tennessee?
Gosh, probably, I don't know, 6 or 7 years maybe.
How long have you known Mr. Gray?
My grandson's 19, so 19 years.
Now, he was in prison for a bit of time.
He was.
Is that why you're saying 6 or 7 years?
Well, no, prior to that, they lived in Dixon.
Okay.
Yeah, and then they moved to Waverly.
When you say they, you mean who?
My daughter and my grandchildren.
And Mr. Gray?
Yes,
Now, Mr. Gray, I understand, has lived either in Waverly or Dixon his entire life.
yes, that's correct.
And in addition to the 2 children that he has with your daughter, does Mr. Gray have other children?
He has 5 boys.
5 boys.
Yes, and then my daughter also has another son, and Landon treats him just like he's his too. He's good to him.
And my next question is he a good father?
Yes, he is. He's a very good father.
Now, since 2015, has Mr. Gray been convicted of any crimes?
2015. Since he got out of, when he got out of jail, is that what you're talking about?
Yes, ma'am.
No, not that I'm aware of.
And he's living in Waverly now, or was living in
Was
Waverly?
living in Waverly, yes.
You know where Mr. Gray plans to reside if he gets out?
Yes, with his son, with his oldest son.
And I understand that to be Gordon Gray.
Yes, in Dixon. He lives in Dixon.
Now, Mr. Gray has been under investigation for some 15 years for this crime that we're here about today. Is that correct?
I think so.
And he knew about that the whole time, correct?
Yes, he's known.
Now, he's worked in
Sir, I'm sorry. I don't know if he's known he's been under investigation for 15 years.
Okay,
I'm so sorry I didn't answer that one
that's
properly.
fine, that's fine. We anticipated your daughter testifying. Where's your daughter today?
She had to work. She just started a new job not too long ago, so she couldn't take another day off.
You know where Mr. Gray was working?
He was working for a trucking company. I don't know the name of the company. I just know the people. David Rose's son-in-law.
Does the name Clayton ring a bell?
That could be. I don't know. It was a nice truck. Landon went back to school and got his CDLs, and he was driving for that gentleman.
Have you ever been in trouble?
No, sir.
Okay. And did you vouch for Mr. Gray's reliability?
Yes.
Those are my questions, Ms. McCaleb. General Crouch may have a few for you.
Okay.
Oh, Crouch, you have questions?
Hey, Mr. Crouch.
Thanks for being here today. I only have one question. What's your daughter's name?
Jamie.
Her last name?
Jamie James.
Anything else? Thank you, ma'am. You may step down and have a seat in the courtroom if you like. You may call your next witness.
Mallory, if I mispronounced his first name.
Where from the testimony given in this case be the truth?
Could you state your name, sir?
Ronnie L. Mallory.
Mr. Mallory, and how do you know Mr. Gray?
That's my son.
Son? And how long has Mr. Gray lived in this area?
Oh, I guess about 2089 or something like that.
Where was he born?
Clarksville.
He was born in Clarksville. And has he resided either in Waverly or Dixon the majority of his life?
No, he was in Nashville at one time.
How long was he in Nashville?
I think about maybe 2 years or 3 years.
Other than that,
He lived in Dixon.
your son, he doesn't have any mental conditions that would make him a danger to the community, does he?
You know, he got some kind of problem with, I think it was high blood pressure and stuff like that. His mental, just different stuff.
But no mental conditions.
No, sir, I don't think so.
Have you ever been in trouble?
Who, me?
Yes, sir.
Teenage years.
Teenage, okay.
Yes, sir.
How old are you now, sir? If you don't mind me asking.
77.
77. And would you vouch that your son's reliable?
Oh, yeah.
And you told me something out in the hall about what you taught your children about facing their troubles. Can you tell the court what you taught
Yes,
your
sir.
son?
I always had told them that if a problem come up, you don't run from a problem. You face that problem. Whatever the consequences is, you just face that problem. See, God will work it out. Landon was the only one really that listened to me. I had 3 boys and, well, 2 of them, my oldest son, he died. And Landon is the only one who would really listen to what I was saying.
Mr. Mallory, thank you for your time. Those are my questions.
Question from the state. Thank you, sir. Mr. Miller, you may step down and have a seat in the courtroom.
You state your name, sir.
Landon Gray.
Okay. Mr. Gray, you understand you're charged with murder, right?
Yes, sir.
Now, this investigation started in when?
2010?
2010? Were you aware you were under investigation?
Yes, sir.
You stayed in this community.
Yes, sir.
You do have a prior record, correct?
Yes, sir.
Have you missed court intentionally?
Never missed court.
Have you ever been charged with a failure to appear?
No, sir, not that I know of.
Not
Never
that
been
you-
arrested for failure to appear, so no.
You were working at a trucking company.
Yes, sir.
How long were you working there?
I think like 6, 7 years.
And have you ever missed work?
Never missed work.
Is that job still waiting for you if you
Yes,
were
sir.
able to make bail?
Yes, sir.
Judge, any other questions? I think we've done that. I'll pass it.
Do you have any questions?
Good afternoon, Mr. Gray. So this is just your bond hearing. I'm not here to cross-examine you about the facts of the case or the investigation. However, I have a couple of questions that may overlap, and if your attorney objects, I'll stop.
That's fine.
All right. So I'll stop until the judge rules. First one is on a failure to appear. I don't think you've been convicted of one, but you were arrested for a failure to appear.
I don't remember being arrested for failure to appear.
Do you remember being charged for failure to appear in Humphreys County in 2022 on a domestic assault?
Was arrested for that.
Thank you for
And
clarifying.
And that was about a fine that wasn't paid on time, to be exact. So Chris Davis came, led me, got me, let me pay the fine, and I went to work and still didn't miss work that day either.
All right. But you were arrested on a failure to appear.
Was arrested. I didn't know that was a failure to appear. I thought that was a fine
Fair enough. Approach the witness.
Yes.
Mr. Gray, I just want to briefly go over some of your prior criminal history, because that's one of the factors that the court considers when looking at bond. If you would take a minute and review those and tell me if that's an accurate depiction of the crimes that you've been charged and convicted for.
Yeah, the 1997 stuff. Yeah, was on probation for all that stuff. Community corrections. Didn't miss any of that either. Showed up on time, passed that, done that. Then the 2009 stuff would be what I went to prison for. Paroled on that. Never missed anything there either. Finished my parole when I was supposed to. Done what I was supposed to do.
Well, are you disputing any of those convictions that are listed?
I mean, they're, I would say, that's what they are.
So, Mr. Gray, just to be clear, you were convicted of possession of a weapon by a felon, and that was August 26, 2009?
Yes,
And you were convicted of possession of Schedule 6 drugs not less than half an ounce in March of 1997,
well, yes, sir.
theft of property, August 26, 2009, felony,
Yes, sir.
aggravated burglary, May 4th, 2009, Dixon County,
Yes, sir.
Schedule 6 drugs, March 25th, 1997, Dixon County,
Yes, sir.
another count of Schedule 6 drugs, March 25th, 1997, Dixon County,
Yes, sir.
reckless endangerment with a deadly weapon, April the 9th, 1997, Dixon County,
Yes, sir.
Schedule 6 drugs, March 28th, 1997, Dixon County,
Yes, sir.
Schedule 6 drugs, March 23rd, 1997,
Yes, sir.
then Schedule 2 drugs, cocaine, September 4th, 1999.
I don't remember that, but yes, sir.
All right. On some of these, and I will make this an exhibit, please.
Okay, there's Exhibit 1.
And Mr. Gray, on a couple of those cases, you were placed on probation,
Yes, sir.
and you had your probation violated a couple of times.
I don't remember ever having my probation violated, Mr. Crouch. I mean, if you say it was violated, I'll take your word for it. I just don't.
This is a
Recall.
it's a technical record, and I want to make
Yeah.
sure it's accurate, because I don't want to suggest something that you were not charged with, but I'm now looking at your NCIC report, and I had identified on here a couple of occasions, turn to them. You were placed on probation for 8 years,
Yes, sir.
and you went to the West Tennessee State Prison, and then your probation was revoked when you made parole on that. That violation occurred on September 15th, 2010.
Yeah, so when you put me on probation in 2009, if that's, yeah, I'm just trying to figure this out. When you put me on probation in 2009 for those charges, the pending indictment for the cocaine sale was already kind of out in the air also. So I guess you ran it all together. I don't know. But I never came to court for a violation of probation or anything like that. I never, I don't know. I don't even remember that. But no, I never came and you said my probation's violated, go to prison. I went to prison for the cocaine sale.
Well, you were charged with selling cocaine while you were out on probation.
I was actually not on probation when I caught that cocaine charge, if we're being technical. Yeah. The cocaine sale was April of 2009, is what you just said.
Well, this is your criminal history, and you can see the identifiers with your full name. And if you'll look where I have the asterisk marked, it says that your probation was fully revoked for you to serve.
Yeah,
You see that?
I do see that.
There's a couple more instances where you were on probation and there was a violation of probation issued and you were revoked.
Okay, right. I don't know, you saying a couple instances, I was on probation for the 1997 stuff. I was on community corrections, correct?
Yes, sir.
1997. And you saying I revoked that probation?
I'm saying that I'm asking you, to your knowledge, now that we have discussed your criminal history, has your probation ever been revoked?
On the piece of paper, it's saying it's being revoked, but I wasn't, okay, I get you. I wasn't on probation at the time of the drug sale, is what I keep saying. The drug sale, I got indicted at the drug sale was in April of that year. So I wasn't on probation technically yet, but I did sell the drugs. I did get convicted of them. I did get put on probation prior to that. And then the way I understand it, you ran it all as 8 years to serve, and I went to prison for it.
Okay.
But you never brought me back to court and said, your probation is revoked.
Well, on a hearing on a bail matter, I'm going to allow it over the objections.
Judge, I would ask that Exhibit 2 be placed under seal in the court's file because it has some information, identifiers that are pertinent to the defendant, and I wouldn't want the public to have access to a social security number.
It'll be placed under seal after this hearing.
Yes, sir. After the hearing. Okay, so Mr. Gray, those are all the questions I have about your prior criminal history. I do want to talk to you about the time while you've been in the Dixon County Jail on the arrest in this case. Are you currently in the Dixon County Jail?
Yes, sir.
And have you, in the Dixon County Jail, are you allowed or provided a tablet in which you can use to send text messages?
Yes, sir.
And have you been sending text messages to Miss Jamie James?
Yes, sir.
And in those text messages, why does Miss James tell you that in the real world that she's terrified of you?
She was talking about, I would say, you asked me to speak for her.
Sure.
She was talking about,
This is another individual stating that she was terrified of him.
Yes, this is a text conversation between the defendant and Jamie James. We've already heard some testimony from Miss McCaleb saying that Jamie James is the mother of 2 of her grandchildren.
Well, number one, I think he can simply he can answer if he's aware of any reason or basis for it. If he doesn't know of any reason, then that's his answer. Overrule the objection.
I would go with what the judge has said. I don't.
Sometimes that's a smart thing to do,
Yeah,
and sometimes
yeah.
it's not.
Well, we were actually in the middle of breaking up if you're going into the whole context, or she was in the middle of breaking up if you're going into the whole context of that text exchange. And she made that statement. But if you're reading it and you're going off of it, you probably see why I asked questions, and maybe those questions wasn't answered directly. But I hadn't done anything to terrify anybody. If I had, she wouldn't still be in communication and be supportive of me trying to be out of jail and whatnot. But that was in the middle of her breaking up with me, would be my response to you, if you want me to just answer you.
Yeah, sure.
With my honesty.
Yeah,
But
and I appreciate that.
yeah, I hadn't done anything or doing anything. I'm grumpy. I work a lot. I mean, I like to watch football, not be bothered.
Yeah, I do too.
But I mean, other than that, I mean,
Has there ever been a domestic assault between you and Miss James?
there has been, yes, sir.
I'm sorry.
Well,
The
Judge,
objection is to the admissibility or of the fact that he's been charged with domestic violence.
Well, Judge, in the context, there is a communication from the jail that we have in which Miss James says that out here in the real world, I'm terrified of you. So I'm asking the defendant about his criminal history, which has been made an exhibit to this court, Exhibit 2, in which he was charged with domestic violence. There was also a failure to appear, which was later dismissed, but a failure to appear on the domestic violence case. I think this is well within the scope of the issues that the court should consider when releasing the defendant, considering a bond reduction, because he was living with this woman until he was arrested.
I'm going to overrule your objection based on the fact that part of the consideration that the court has to consider is not, are set forth in the factors for the amount of the bond to be considered. And one of those factors, I think, in this court's opinion, is whether or not there is any threat to the general public or to any particular individual that, would be as a result of his being released on bond. I certainly think you can redirect him and question about any of that, but it's my opinion that it would be relevant on these issues. Overrule the objection.
So what was your question again exactly?
I asked about the domestic assault.
Had I been arrested for domestic assault? Yes, sir.
Okay. And that was with Jamie James?
And yes, sir. And that was, when you talked about that, that was a fine that I didn't pay on time, and they write you a warrant or whatever on it. And like I told you, and you could check it, they picked me up at the county line, and I paid the $252, I believe what it was, and no harm, no foul. And I was arrested on domestic violence because we got into an argument, and when the cops showed up, being that I was the one raising my voice, and the officer can tell you, we get along great now. She wanted me to sit on the curb and cool down for a minute, and I didn't want to sit down on the curb. So being that how they looked at it, I could be the aggressor, they took me, to jail. And then it was dismissed, hadn't been any other issues. Like I said, that text exchange, if you go into the whole context of it and not just one little snippet of it, it was basically her saying we shouldn't be together, whatever. And we're fine from there. Text exchange since and going forth, and I'm sure you look at them, we're fine. There's no issues, no problems with me, her mother, father, stepfather, anybody else, grandmother, anybody. So, no, I'm not a danger to her or anybody else, if that's your question or that's what you're trying to get to.
Thank you for your answer. Also, if you were to make bond, would you be moving back in with her?
No, I'm gonna stay with my son, transportation, trying to get back and forth to work, closer, whatever. After that text exchange, somebody say they want to break up with you, you gotta take that for what that is and move on,
That you were living with her in Humphreys County,
Yes, sir.
and that's where the domestic assault occurred.
That's where I was arrested, yes, sir.
Okay. And after that case was dismissed, and you were picked up and arrested on the case we're here on today,
Years later, yes, sir.
2 years later.
Well, yeah.
And then in jail, you're saying that that's when the breakup occurred?
I mean, yeah, that's what you're saying.
I'm not saying, I'm asking you. I don't see anything about a breakup.
Well, like I said, if you read the whole text exchange and not a snippet, that's what that was about. You have to read the whole text exchange and not just a snippet, of it and, you know, pick what word you want to pick out of it, which terrified sounds like a terrible word, you know?
Thank you. So now, Mr. Gray, let me ask you about, I'm not asking you about the facts of the murder investigation, but I do want to ask you some logistical questions. Were you interviewed multiple times in this case?
I was interviewed in 2010, twice. I was interviewed in 2000 and maybe 13. And then I was interviewed when Mr. Davidson arrested me.
Okay.
So I was interviewed 4 times.
Thank you. I'll pass the witness.
Redirect. Finley.
I don't have the benefit of knowing the text exchange between you and your ex-girlfriend, I guess it would be, right?
Yes, sir.
Miss Jamie James.
Yes, sir.
But do y'all get along?
Yeah, we get along great.
Okay, in fact, who's been my primary point of contact?
I say Jamie James,
Okay. She's been talking between you and I,
trying to help me get released. Yes, sir.
and she's worked diligently to do that, hasn't she?
Probably harder than she should, yes.
All right. That's all I have. Thank you, Mr. Gray.
Right.
Anything further, Mr. Crouch? Thank you, sir. You may step down and have a seat by your lawyer. Finley, do you have anything else? All right, the defense has rested their proof on this motion. The state have evidence you want to offer?
Sergeant Davidson, will you state your full name, please?
Kirk Davidson,
And where are you employed?
the Dixon Police Department.
Thank you. And what is your role in this case?
One of the investigators within the case was assigned by the DA's office.
When were you first assigned to this case?
2020.
2020. And how did that come about in 2020, 10 years after the homicide
The
occurred?
assistant chief at the time had spoken with you, and I was designated to come over to your office and start working on this case.
The investigation at that point in time, when you were assigned, had been going on for some 10 years.
Yes,
Did I create a task force to
you did.
renew the investigation?
Yes, you did.
And you were placed on that task force?
Correct.
Once assigned to the task force, did you have an opportunity to review the entire case file from offense date through when you were
Yes.
assigned? And you've heard the defendant testify that he was interviewed 3 times by law enforcement,
Correct.
and you were a portion of one of those interviews.
It would have been the 4th one, or the 5th, 4th or 5th.
Either way,
There were several.
He's been interviewed several times.
Yes,
And I'm asking you these questions in relationship to a bond condition, which is the defendant's likelihood of conviction. That is a bond factor that the court can consider. So let me lay a little bit of a background. Who is the victim in this case?
Josh Strickland.
Josh Strickland. And where was Mr. Strickland's body found?
It was at the Bellevue Theater, right on the Bellevue exit.
That's in Davidson County.
That's in Davidson County.
And can you give some testimony as to how his body was found?
His body was discovered burned up in a truck, a Dodge truck, 4-door truck, on the back side of the theater.
And was there an autopsy done?
There was.
What was the autopsy summary?
Revealed that he had been shot prior to the fire, and they recovered a bullet out of his body.
And from that point forth, a criminal investigation started.
Correct.
This case was initially investigated by Metro Nashville Police Department,
Correct.
and at some point, a couple of years into it, was transferred to the Dixon Police Department.
Correct.
So I'm working up to this. When the defendant was initially interviewed, do you recall what he told law enforcement about his involvement in this case?
That he was with Josh that day, that evening.
At the movie theater?
They had been to the movie theater.
And by the way, was this movie theater, was it open or closed?
No, it was closed because the May 2010 flood flooded it out, and it was closed. It was a vacant building that did have a security detail assigned to it, and there was people that would drive around ever so often, and they would report if they saw anything or not.
But this wasn't a typical movie theater that was full of cars, people going
No.
to movies.
This was a vacant piece of property.
Vacant piece of property in Davidson County. I think it was the Bellevue 10 or 12. Was that the name of it?
I believe, I don't even know what it was called at the time. You can see it from the interstate from 40.
But in May of that year, it had been flooded out.
Correct.
All right. So Mr. Strickland's body is found in this burn-up truck, and he's got some bullet holes in him. The defendant was interviewed about his involvement in this. Is that correct?
Correct.
What do we know about that day as far as your investigation is concerned?
He was with him majority of the day. We have witnesses that say he was at a sub shop eating with him.
The objections, what? All right,
I'll read.
Pull that microphone closer to you, Jackie. Can you repeat your answer?
We interviewed some witnesses, and they had said that they were together that day.
I think the hearsay objection would be valid. Sustain the objection.
Sergeant Davidson, did the defendant tell you he was with Josh Strickland that day?
Yes, in that interview, he did.
In the interview, he
Interview.
said he was with Josh Strickland?
Yes.
The victim,
Correct.
all day?
Yes.
And have you observed some video footage that was obtained from Walgreens in Nashville?
Yes,
And is the victim's vehicle, a truck, seen on that video?
it is.
Is the defendant Landon Gray in the video?
You cannot see him inside the vehicle.
Does he acknowledge that he was inside the vehicle?
That they did go up there, yes.
Were they involved in a drug deal, to your knowledge?
Yes,
Did the defendant, Mr. Gray, tell you they were in a drug
he
deal?
admitted that.
All right. Now, what does the defendant in his first interview say happened in the Bellevue Theater flooded parking lot?
He said that they were up there going to meet I think it was the Hondurans, because the weight of the drugs was wrong, and that Josh had been shot by them.
Did the defendant tell you he observed the Hondurans shoot Mr. Strickland?
There is a statement that says that. He
The
didn't directly
defendant's
say it.
statement?
No, it's his Jamie James's statement.
Okay. And
Sustain.
did the defendant in any of his interviews mention that he had gunshot residue on his hands?
Yes, the interviews he had with Sergeant Peterson at the time was inconsistent. Each story was a little different.
In one of those statements that the defendant made, did he discuss gunshot residue
Gunshot residue, yes.
on his hands?
Mhm.
What was his excuse for having gunshot residue on his hands?
Fireworks, we had shot some fireworks at one time, he said, and then in another statement, he had shot back at the Hondurans.
So in one of his interviews, the defendant says he's at this abandoned movie theater, sees the Hondurans come in, shoot Mr. Strickland, and that he has gunshot residue on his hands because he shot back.
Correct.
All right. Now let's move on to one of the more recent interviews. Did the defendant discuss that the murder had occurred in Dixon County?
He said he was a witness to the murder in Dixon County.
Who did he give this statement to?
Sergeant Peterson,
Sergeant Peterson. And what did he say? What did the defendant say happened in Dixon County?
that he watched Jack Hogan shoot him
Where did he say this occurred?
over on Highway 70 West at Josh's parents' house.
Josh's parents' house. The victim's parents' house.
Correct.
How did he describe Mr. Strickland as being murdered at Mr. Strickland's house, his parents' house in Dixon County?
He was in the passenger seat of his pickup truck, the Dodge. Mr. Hogan was in the driver's seat. As he walked up, he heard a gunshot, said that he heard Josh say, "Why'd you do that?" And then he shot him again. And then Jack handed him the gun, handed Landon the gun and said, "Now you have your fingerprints on the gun."
So the defendant, in his interview, this being a latter interview, said he observed Jack Hogan shoot Josh Strickland. And
Yes.
Mr. Hogan placed the gun, the murder weapon, into Landon Gray's hands.
Correct.
Thank you. I'll pass the witness.
Mr. Finley, you may cross-examine.
Correct.
General Crouch made a task force just for this case? Or
Correct. It was a cold case investigation.
so for all cold cases or just,
He went through some files, and I was just contacted by the assistant chief at the time, and then I was assigned over to his office.
So I mean, was it just one case or was it several?
It was one
cases?
case that I was assigned. I don't know about any other cases or task force that were created at the time.
All right. And you didn't conduct the first interview? That would have been done in Nashville?
That would have been in Nashville. Well, actually, it was done it was in Dixon, I believe.
By Nashville or
By-
Metro?
Metro Nashville is the one that started the investigation, correct?
Now, and the defendant admitted to being with the decedent, the victim in this case. Okay. And he said something about shooting back at the Hondurans or something, fireworks. Do you remember the order in which those
There was a
statements-
couple of stories that they were inconsistent with one another.
All right. And now, you've been in law enforcement how long?
A little over 14 years.
And even witnesses have inconsistent stories frequently, correct?
They all were very consistent compared to his stories.
No, I mean in
Of-
general terms.
in
Is it
general-
unusual to have a witness have their story change over time?
Yeah, it's possible.
Now, it's my understanding the first autopsy, there's several different coroners who weighed in on this original autopsy,
There was a
correct?
couple of opinions.
Now, the first opinion was that the decedent was killed in Nashville, and that was because there was smoke inhalation or some signs of smoke inhalation.
There was a little residue.
Now, I don't mean to be morbid or obscene or, otherwise inappropriate, but I gotta ask, I mean, the subsequent opinions on the autopsy, they didn't do the first autopsy, correct?
The medical examiner's office,
Right.
is that who you're talking about?
Yes, sir.
They done the original autopsy.
But the doctor who did the last one, I mean, there's different opinions, correct, on,
They reviewed the file. There wasn't, the autopsies there wasn't more than one autopsy, actual physical touching of the body. It was just reviewing the file.
okay. And these other doctors who looked at the original autopsy, just the report, they decided, no, there wasn't smoke inhalation.
Correct. That was all off the autopsy reports.
You have
I
no
think it
idea
was the percentage. The percentage is the factor that they were talking about,
percentage of what?
of the smoke in the esophagus.
Esophagus?
Mm-hmm.
When I say lungs, I'm inaccurate, or was there?
I would
smoke
have to
in the
review it
lungs?
again. I don't have it in front of me right now to read.
You can't really explain why there's differing opinions as to smoke inhalation or
No,
not.
that would have to be something the medical examiner had to come in and testify to.
That would be an important thing in this case, because that would determine whether the decedent was killed in Nashville or killed in Dixon, correct?
There could be a factor of that.
All right, if he was alive and shot, and then the truck was set on fire, still breathing smoke, that's how he would get the smoke inhalation. That would be a possible theory, correct?
That's a possible theory.
The other one being he was shot in Dixon and transported to Nashville where the fire started.
It also could be from if he was a heavy smoker. We don't know. There's a lot of factors that come into play with that.
Have you ruled out or determined whether or not he had a smoking issue? Or,
Just can go off what the autopsy report says.
but you hadn't talked to friends or family about whether he smoked
He
a pack
did,
a day?
he was a smoker. Yes, he was a physical smoker.
Okay. And so the doctors are saying, well, that could be from cigarettes.
Could be. Just another opinion.
Okay. And this is from 2010, this shooting, this death, correct?
2010.
Now, the person who Mr. Gray indicated would have committed the murder in the final interview, I guess he would have given, can you tell me that name again, please?
Jack Hogan.
Jack Hogan. I'm not from here. I don't know Mr. Hogan. Have you heard of Mr. Hogan?
I have. I've never had any dealings with Mr. Hogan.
Does he have a record?
He does.
Is it violent?
I just heard the name. That's all I know of him. I wouldn't know him if he walked in the room. I didn't interview him during the investigation. That wasn't part of my detail.
And you're saying that Mr. Gray indicated that Mr. Hogan committed the murder and handed him the firearm?
Correct.
That's his final,
That was-
last statement.
That was one of the final statements he did with Sergeant Peterson.
And Mr. Hogan, I guess, insinuated, hi, now you're on the hook too because you touched the gun?
Because he handed it to him. That was your client's statement.
Right. That's what you got, you interviewed.
No, Sergeant
Oh.
Peterson did.
Okay. You watched the
That was,
interview,
I watched the
obviously.
interview.
Okay. So then, we don't know whether Mr. Hogan's someone we that would be reasonable to be afraid of?
I don't know. I don't know that. I don't know him.
Mr. Gray indicate during that interview whether he was afraid of Mr. Hogan.
He didn't say that. He was on the same piece of property as him, so he wasn't too afraid if he showed up where he was.
Well, there's being afraid of somebody, and if you watched them shoot somebody in cold blood, would that kind of make a reasonable person afraid?
Make a reasonable person to report it.
Right. Unless they were threatened.
It's possible. I wasn't there.
You know whether any investigators had kind of went to Mr. Gray and pressured him to make a different story or say something different or
Nothing to
anything
know.
like that? I'm sorry,
No,
you don't know? Or
not that I know. I interviewed him that one time at the Humphreys County Sheriff's Office. That was the only conversations we had.
That's all I have. Thank you. Are you aware that Mr. Hogan was convicted of murder? Is that true?
I've never ran his criminal history. I have no dealings. I have no information on him that I've seen.
But you're in charge of this investigation, right?
I was part of the task force.
Somebody has told you that somebody shot the decedent, and you didn't investigate that person? or
That
look
was
them
not
up?
part of mine. I can't testify to that. And he was looked into and he was interviewed, but not by myself, by me.
Okay.
I didn't go interview him.
That wouldn't be in the file that you reviewed?
During the 2020 investigation, that's what I'm talking about. He was interviewed during that time frame, but I was not the investigator that did that.
Okay, so you can't testify as to whether or not Mr. Hogan was convicted of a drive-by shooting or convicted of some cold case murder?
I haven't
himself?
seen his criminal history.
Redirect.
Sergeant, just briefly, to follow up on the questions about the medical examiner. We were talking, you said about, go through that again about the percentages that, what were you saying?
The
about-
percentages of I guess it's carbon monoxide or dioxide or something like that that was in his esophagus.
I didn't want to
the
put
per-
words in your mouth.
yeah,
We're talking about carbon monoxide.
Carbon monoxide, yeah, it
And
was the percentage.
Percentage of carbon monoxide as listed in the autopsy results?
Right.
So the debate was whether that percentage, and I'm asking you, was the discussion between the folks looking at the autopsy, whether that percentage meant that he was a smoker or whether he was alive when the vehicle was set on fire?
Correct. That was the difference.
All right.
That was the discussions they were having.
Thank you.
Anything further? Thank you, sir. You may sit down. You have another witness? Mr. Finley, do you have any rebuttal proof you wish to offer? And I'll hear you in argument.
Your Honor, I'll just run through the bond factors. Mr. Gray has lived in the Dixon County, Waverly community his entire life, except for a few years where he was in Nashville, which is also very close to here. And then the time he spent in prison. But other than that, he is a lifelong resident of this community. He is currently gainfully employed, and his employer is waiting and keeping his job open for him, which is somewhat amazing because it's my understanding he's been incarcerated since May. And here we are, September, and they're still ready and willing to put him back to work. His family ties and relationships he is very, very deeply rooted in this community. He has 5 adult children. I don't believe it came into evidence, only one of whom does not live in this area. He is in the Air Force. The rest of his friends and family, everyone's living here in the Dixon and Waverly area. But for his criminal history, there's been no real proof about Mr. Gray's reputation or his character. I did ask his father about his mental condition, if he had any issues. He has none. The defendant, again, does have a prior criminal history. There are some drug cases on there. There are some cases that might be considered to be of a violent nature and that it's reckless endangerment and aggravated burglary, but there are no assaults, there's nothing like any attempted murders or anything like that. And there is no record of his failures to appear. He indicated he missed probably a status date to pay on a court cost or something to that effect, and he had that straightened up right away. There's no record of the defendant fleeing to avoid prosecution. The next factor would be the nature of the offense and the probability of conviction. I suspect we've gotten just a very, very small taste of the state's case today. Not near enough to go into the strength of the state's case other than they have impeached the defendant's original story. Just because somebody's story changed doesn't make them guilty. In fact, very few witnesses I've cross-examined have consistently stayed with stories, especially the longer time has gone. We're 15 years past the alleged offense date here. That being said, the nature of the offense is the most serious one that exists, Your Honor. It's first-degree murder. And we go to prior record and likelihood that the defendant is a danger to the community. The Thomas sheet that we looked at he has gone a decade and a half without any felony conviction. I'm not aware of any misdemeanor convictions that I could see in the NCIC, although I only briefly perused it. I am referring to the Thomas record as a more accurate depiction of the defendant's record. He's gone 15 years with no trouble. I think that's a substantial indication that he is not a danger to the community. The identity of responsible members of the community who were vouched for his reliability, Your Honor has heard testimony from 2 people, and they seem credible and genuine and sincere. They don't have any criminal history, and they tell us that Mr. Gray is reliable. The fact that he has a job still waiting for him also echoes the fact that he is a reliable member of this community himself, and that he has clearly stepped away from who he was back in 1990, in the early 2000s, and even as late as 2009. Your Honor, there's a final catch-all factor in the code. It says any other factors bearing on the defendant's ties to the community or bearing on risk of whether he willfully failed to appear or whether he's lawfully present in the state. He is a citizen. There's been no proof he's not lawfully here, and he's lawfully here. But, Your Honor, Mr. Gray was interviewed several times. I'm sure a lot of pressure was put on him by law enforcement. Leave this community. He didn't flee to California, or go to Mexico, or leave the country, head down to Belize, or anything like that. He stayed right here for this whole 15 years, knowing that they were looking at him for this. He didn't run. Your Honor, bail is not punitive, as the court says. It's just to assure his appearance. I think with a bail as low as $100,000, we can assure Mr. Gray would be here. I suspect you could OR Mr. Gray, and he'd be in court every single time he's supposed to be. I understand I'm not asking for an OR bond. I'm just saying as low as the court is comfortable to go is what the defense is going to ask. But I'm confident Mr. Gray will be in every court appearance. But I think Mr. Gray intends to prove his innocence in this case, Your Honor. Thank you.
Is this case set for trial?
No, Your Honor. And to be clear, not speaking for Mr. Finley has just now been appointed, and in fact, I think
this came out of the March term of the grand jury here in Dixon County, is that correct? So he's just been arraigned and has just been appointed counsel in May?
no, the public defenders had this case, and they were provided discovery, and I asked the public defender's office to transfer the discovery to Mr. Finley. That all
They
just
withdrew.
That just happened this week, so Mr. Finley's barely seen the file.
All right, August 27th is the day that Mr. Finley was appointed. All right. So which court is this case tracking? In other words, is this tracking in my court or is
Yes,
this
sir.
tracking?
It's your court, Your Honor.
All right. All right, go ahead, I'm sorry.
Thank you. Judge, I would ask the court to consider three factors in review of the bond. One is the defendant's prior criminal record, which we have submitted two pieces of evidence for you to review, for the court to review. One are the Thomas convictions, which are all felonies, and the second is the defendant's NCIC report. Notably, Your Honor, two of those felony convictions are violent offenses. Reckless endangerment with a deadly weapon and aggravated burglary. I would argue that the defendant does pose a risk to the safety of the community if he is released on any type of bond. He has a lengthy criminal history, and despite the defendant disagreeing with me, the opportunities that he has had to serve on probation have been revoked, and that is clear when you look at his criminal history. The few times where he was not imprisoned, he was on probation, and his probation was revoked. And finally, the factor of the apparent probability of conviction. In Mr. Finley's right, we've just seen a very brief glimpse of the state's proof, but in two of the defendant's own admissions, both of them are consistent, and he puts himself at the murder of Mr. Strickland, one in Davidson County and one in Dixon County. He also, in one of his interviews, says that he has gunshot residue on his hands, and in the second interview, says that the murder weapon was in his hands. And there's been, well, I'm not going to argue the entire case, but the likelihood of conviction, just based on the entirety of his interviews alone, is highly probable. I would ask the court to not reduce his bond.
Mr. Finley, you have anything else? In considering bond request or a request for the reduction of bond, of course, let's consider those factors that are set forth in Tennessee Code Annotated 40-11-118, subsection B, and those include the following. The defendant's length of residence in the community. There's been testimony that he's been in and out of Dixon County for many years. He's lived either here or in Waverly for quite some time, except for a 2-year period that he resided in Davidson County, I think it was. So it does show that I think you could consider Humphreys County to be a part of this community in the general area, certainly within the 23rd Judicial District. His employment status and history of financial condition, I mean, obviously he has a job, and as Mr. Finley points out, that job is waiting for him if he were to be released. Family ties and relationships, the grandmother of his children, I guess it is, or some family connection there, and then his father both testified and vouched for his reliability, except of course his father was very, honest with the court about issues that may have been there. But in any event, I do find that there is a family connection. His reputation, character, and mental condition, I don't find any evidence on that. His prior criminal record and record of appearance at court proceedings, record of flight to avoid prosecution or failure to appear. Court is cognizant of the fact that there was a conviction on his record that's been introduced for possession of a weapon by a convicted felon that was here in Dixon County in 2009. There was a theft of property, a felony theft of property, theft of property rather, in Dixon County in August of 2009. Burglary in May of 2009 here in Dixon County. A possession of drugs possession of drugs in 1997 in Dixon County, possession of drugs in 1997 in Dixon County, reckless endangerment involving a deadly weapon in 1997 in Dixon County, schedule of 6 drugs, 1997 in Dixon County, schedule of 6 drugs in 1997, and schedule of cocaine, schedule 2 drug cocaine possession in 1999. So, I mean, he does have an extensive criminal history. And it may be, there may be logical explanations. The state argues that that should be considered by the court in determining his risk of appearance and also the safety of the community. The interesting part of that is that up until about 2009, he had an extensive criminal history. Then the testimony is that in 2010 and thereafter, he was interviewed multiple times by law enforcement officers regarding the death of the victim in this case. And from 2010 forward, he doesn't have any criminal charges. It may be a coincidence, or it may be obviously having related to what happened in 2010. The statements that's been given are that he was present, according to the testimony. He has admitted that he was present and gave conflicting statements about when he was present and who was responsible for the death of the victim in the case. And it's true that it's not unusual for witnesses and even defendants to give conflicting stories. But giving a story one time saying that you were present and that he was killed, the victim was killed by someone from Honduras and you returned fire, or that it was fireworks that accounted for the gunshot residue, and another time saying that it was Mr. Hogan who supposedly committed the crime and then handed him the gun to do that. Those are significant variations in his statements. And as a result of that, I think that it does weigh on his criminal record, does, in my opinion, carry great weight. And that what I've just touched on really goes to the possibility or probability of conviction. And the court's of the opinion that I've only heard a bit of the case, but it does sound like to me that he has admitted being at the scene of the murder of this victim, and that he has gunshot residue on his hands. According to him, there's an explanation for that several different ways. In any event, that would be for a jury to determine, but it does strike me, based on all my years of being a defense lawyer and now as a judge, that, in my opinion, creates a pretty strong case for the state to proceed. The nature of the offense and apparent probability of conviction, it is a first-degree murder case, and as a result of that, if he is convicted, then he would be faced with a mandatory life sentence with no possibility of probation, obviously. The defendant's prior record and the likelihood that because of that record, he would pose a risk of danger to the community. I do acknowledge that there's been no recent convictions, but his prior convictions involve violent crimes. And as a result of that, this court is of the opinion that his prior record does present a risk of danger to the community. The identity of responsible members of the community, I've touched on that, and I think we have had 2 people. Any other factors indicating his ties to the community and bearing on the risk of his willful failure to appear. I have to acknowledge, as Mr. Finley points out, that the defendant's been under investigation as a possible defendant in this case, or at least as a witness, and has been aware of the fact that this case has been under investigation. He's been interviewed multiple times prior to being indicted, and as a result of that, he has stayed in the area. So that is a factor that I think would, in this court's opinion at least, benefit the defendant as far as this court's opinion that he might show up. So based upon all of those things, it is this court's opinion that an appropriate bond is $250,000, and that is the amount that I've set. Bond will be set at $250,000. If he were to make that bond, he would be required to have a GPS monitoring device installed on his person in order to ensure that his location is ascertained at all times. Now, since this is the first instance of it being before the court, I would suggest that we need to set a status day, and I would suggest that January the 7th will be the next status day. Obviously, I want to track this matter, and I'd rather it's been under investigation for so long, it ought to be fairly easy to get this case, not easy, but I would think that the information is available for this case to move forward and try to get set at an earlier date. So see what we can do about, this is September, January the 7th should give you sufficient time for discovery and so forth, and perhaps at that point we can assign a trial date. So. No, they've agreed on a bond source, I think, if there was to be a bond. So. It wouldn't hurt to have that, but it's the docket sheet will reflect that. So I think if you need an order for the GPS before he's released on bond, that would be my opinion. All right, they'll require an order, I'm told by the clerk, so yes, you'll need to prepare an order. That brings to a close our business for the day, so we stand adjourned. I'm sorry.
Ms. Hungerford, who's present in the courtroom today, which was the spouse of the victim, listed with GPS parameters to keep the defendant away from her.
He said have no contact with anyone that's connected with the victim's family, and that means that his parameters are that he's not to, have any, I don't want to address, but if he's living back, if he were to make bond, and I understand that, a $250,000 bond is not an easy bond to make, but if he were to make bond, then he would have a GPS device. It's this court's opinion that he can go to work, meet with his lawyer, and other than that, he needs to be at home. So let's put that in the order as well. There's no reason for him to be anywhere but work or home or meeting with his lawyer. Once he is employed, he may choose to hire an attorney, and if he hires an attorney, then so be it. But as far as his being able to roam the streets of Humphreys County or Dixon County, I'm not allowing that. I'm simply allowing him to be released on bond so that he can go to work if, in fact, he makes that bond. Well, he's not to drive a truck. Where does he drive his truck? Well, I need to put down some sort of parameters about it, because obviously if, Mr. Approach the bench, please. Let's do this.